brave men and women in our military service leave behind their families, homes, and careers in order to answer the call of duty. And without legal protections, returning to civilian life can be a real struggle. That's where USERRA comes in. I'm Steve Matcha. I'm an attorney focusing on employment law, and this channel is to provide you with helpful or interesting information about workplace laws and related issues. USERRA stands for the Uniformed Services Employment and Reemployment Rights Act, and among the many protections that it provides, military service and National Guard members are entitled to be reemployed upon their return from military leave, along with the same pay, benefits, and seniority they would have received had they not gone on military leave. And in fact, the law specifies that they are considered continuously employed throughout their military leave. Naturally, the law is very protective of military service members for many reasons, including some of those we discussed at the outset of this video. As the U.S. Supreme Court explained, this legislation is to be liberally construed for the benefit of those who left private life to serve their country in its hour of great need. Still, many employers are holding out, including employers within the very government military members serve. Take, for example, Park versus the California Military Department. I've had the privilege of working on Lieutenant Colonel Park's legal team, and throughout the litigation, the state has been hanging its hat on state sovereign immunity. So you may be asking yourself, what's state sovereign immunity? To start with, sovereign immunity, that can be thought of like two separate countries. They're independent of each other. They have their own rules and they govern themselves. And intuitively, we understand it doesn't really work if one of those countries tries to enforce the rules of that country as to another country. It just doesn't really work. There's some exceptions to that. For example, if the countries have a treaty and agree to be held by the same standards, but that's a bit beyond the point. As for state sovereign immunity, states do enjoy some immunity from the federal government, although not as extreme as two separate countries. Basically, the federal government sets the standards and the rules over matters of national concern, and the states govern themselves. They govern matters of local, statewide concern. And how that relates to USERRA is states have been saying, well, USERRA, it's a federal law, and we as sovereign states can't be held to that standard. It's, that can't be imposed on us. Now, while Park versus the California Military Department was ongoing, the U.S. Supreme Court decision came out in Torres versus the Texas Department of Public Safety, and the Supreme Court basically said, look, states, in joining the Union and becoming a part of the United States and also receiving the benefit of a national defense, you waived your sovereign immunity as to laws in furtherance of that national defense, and USERRA is one of those laws. So the state had to pivot a bit in Park, and if you'd like to hear both sides, the appellate argument was on May 2nd, 2023, and I'll add a link to that in the description. Arguing for Lieutenant Colonel Park is Brian Lawler, also lead counsel on Torres versus the Texas Department of Public Safety. I'm happy to report that on May 12th, 2023, we won the case. I'll link the decision in the description. I hope you enjoyed this video. Feel free to reach out to me or refer a friend. I'm happy to help. Thanks for watching.